Right, I think we'll get started now. And welcome to the 18th, if I've got my numbers right, annual International Property Lecture enabled by the Herschel Smith Fund. Most of you in this room, and I recognise now some familiar faces, each one of these that we go round, need to have a deep knowledge of this area or a curiosity in it from an associated field. I think I'm the outlier in this room because I really have neither. But as I've been coming to these lectures over the last number of years, I found it a really fascinating and increasingly important area that's really helped me try to understand and make sense of sort of broader ecosystems around the world, because my area of interest really is geopolitics. And I sense, and I'll admit, that it's becoming a bit harder to be confident in some of the geopolitical assumptions sort of underpin stuff as we look at the news now. So often having different angles and looks into other areas that sort of build up this international architecture, for me, is really, really important. Tonight, we have a treat. Professor Robert, or Rob, I think you're happy to send me call you, Moses of the University of California in Berkeley is here to join us. Interestingly, Rob, you are the second professor from Berkeley to give this lecture, the first being Emmanuel Samuelson, who gave the 10th lecture back in 2015. Rob, as many of you know, or more so than I, is the foremost academic expert on US patent law. Now, for much of his career, he has examined patent law doctrines from an economic perspective. Now, although best known as a patent scholar, he has not limited his research to focus only on patent law, but also made very important contributions on copyright, including questions of parody and collective licensing. His 2011 book, Justifying Intellectual Property, however, rejects, I think, utilitarian thinking as offered as a satisfactory high-level justification for intellectual property rights, and instead builds a justificatory theory by combining the thinking of Locke, Kant, and Rawls. The book really is a tour de force, although I have to admit I have not yet read it, Rob. But sections of it have been made compulsory reading here for our undergraduates, and therefore many in this room I know will have read at least parts of his work before. Now, as if all of this was not enough, he's also the co-author of a number of cases and materials and other books, primarily targeted, again, at students, most notably Patent Law and Policy, Cases and Materials, initially solely authored and first published in 1992, but then refreshed with other authors subsequently. And Intellectual Property in the New Technological Age, again, initially solo authored in 1997, and now issued annually in 2 volumes with 3 co-authors. The title of his talk tonight, as you can see here, is Cousins Not Twins, Patent Claim Scope versus the Breadth of Patent Enforcement. In it, if I understood it rightly, Rob will return to patent law, and in particular, the questions of infringement. These are issues that will be of particular interest to UK patent specialists and students who are learning to live with the recognition by the UK Supreme Court back in 2015, Octavia Service Ali Lilly, of a doctrine of equivalence, extending the scope of patents beyond the meaning of carefully crafted claims. He intends to explore the relationship between the rules relating to the scope of patents, such as the doctrine of equivalence, and other rules defining infringement. It should be a real treat. He will speak for about 40 minutes or so, and then, as before, we'll open up into sort of a Q&A session before we get a chance then to sort of move just to sort of individual chats in the margins of the floor. With that, Rob, the floor is yours.
Thank you very much. Okay, so I should start with some thank yous. Thanks to the master for that very nice introduction. Much more substantive than the intros I often get, which is I think this guy does something related to patents, so welcome him or her or whatever. Anyway, grateful for that. And of course, Professor Bentley, Lila Bentley, who's a name in the field that stands very large in the US and elsewhere. It's an honor to be invited to him to present. I thank everybody for coming out tonight. Some of you I know have come a little ways. I see one of my former students, Patrick Gould from the City University Law School, and I appreciate that. And others I know much to do and very little time. You're near the end of a term. So anybody who's dedicating some of your precious free time to this, my goal to try to make it worth your while to some extent. And with that, I think I'll proceed along. So the paper that I distributed has the quality of one of those photos for an Airbnb where it shows like the front door and maybe a window, and you have no idea, like, what is this structure? You know, I'm committing to stay here, but they're only giving me a tiny little piece of it. And I want to try to fill in my presentation the bigger context for this little snapshot that I gave you. If it was confusing, I hope I can dispel some of that by stating the bigger point maybe more clearly. And then what the paper's saying will fall into place. So I appreciate your patience with that. Basically, my themes that I want to go through are to show that this paper here is part of a bigger project. I've gotten interested in kind of you might say, the sort of the legal bones or the legal structure of IP rights. And beginning with sort of the common law origin, the conceptual backbone of IP rights. Much of that work has been pursued, obviously, over the years by some of the scholars around the world. My colleague, former colleague at Boston University, Wendy Gordon, who talks about the role of restitution as sort of a conceptual frame for IP rights. I revert to her work. I'm also interested in plugging this set of rights into the overall framework of what's sometimes called the new private law. And I know that there are a lot of followers in that little subfield here in Britain and on the continent too. The nature of IP rights in that public law, private law frame is very interesting, and I think as a hybrid kind of right. It says some interesting things about the public-private distinction, but the new private law, I think, is a very nice setting to talk about the private law side, sometimes I call the private law moment in IP rights, with respect to IP rights. And from these threads, I try to put together a view of the hybrid nature of IP rights, the statutory public law validity checking side, and the private right of action enforcement side, which is really the private law moment or the private law stage. I try to explain that. So this is part of a bigger set of inquiries where I've sort of been poking at these issues. And you can get hold of these slides if you want. If it bores you to tears, you never have to see them ever again, I promise. This will give you a little bit of a context. I'm not going to run through all of these things. I'm sure you're grateful for that. But this will give you a sense of how this little paper I gave you maybe fits with this bigger frame that I've been working on. So let me get to that sort of hybrid structure from the beginning. A lot of IP now runs through statutory mechanisms, and for the most part, to earn, you might say, the enforcement stage, to get to that private law moment, you've got to pass through either an examination phase for patents or a kind of registration and a kind of ex post confirmation of rights for copyright and to some extent trademark, although the more prominent system around the world of priority based just on filing doesn't require any common law period for trademark use. Traditionally in the US and in a lot of other countries, there is a sense that trademark registration comes after you've begun to generate some value by using a brand. And so the registration phase in trademark, I think, is confirmatory, but also somewhat constitutive of the rights. Anyway, the point is you have that kind of registration or examination phase, but once issued, and then putting aside post-grant validity review, once you get through all of the validity checks, then we treat IP rights as entitlements. We treat them as we've passed through a public law review, we've decided there's some validity here, and they, at that point, vest more fully and become something like your baseline private law entitlement. I'm going to talk a little bit about how that works. But I just sort of divide the life of an IP right, you might say, into these two phases or moments. What's interesting is to think about what it takes to get to that private law moment with an IP right and how it's different from other private law entitlements. That's really a starting point for much of what I think. Now, I'm going to talk about the sort of core nature of each of these phases, or the core nature of IP rights. And I think that for me, as I study them, most IP rights have a property like flavor, and we know that registration, validation, and all of that adds to that sense of a property entitlement. But if you study IP law, you also know that at the enforcement stage, there's a very strong common law quality very often. There is what Professor Gordon calls a kind of mirror image of torts, where we look at an IP, a work or an invention or a brand even, as some kind of benefit that's conferred. And at that point, I'll explain this, I hope, more fully, we shift from a property orientation more to a focus on misappropriation and really, again, the core concept of restitution. Conferral of a benefit that may cause enough value or create enough value that we believe it's actionable or enforceable, right? So you have a sort of a property moment where things are examined, and IP law has a lot of property elements. But at the enforcement stage, even in patent law, which is the most property-like of all IP rights, even in patent law we have, and I know it's controversial here now, but I think it's timely, the doctrine of equivalence, which all of a sudden shifts your attention away from the details of the patent claim and that kind of linguistic textualist exercise we call direct infringement or literal infringement. It shifts your attention away to that broader focus. Was there a conferral of a benefit? Is this conferable? Is this conference actionable? Has it created enough benefit for this defendant for us to find liability separate and apart from the details of the property considerations, right? So, so too, of course, in trademark law, where likelihood of confusion, as I was talking with Lionel before, is a classic common law formulation like fault or like approximate cause. It's very open-ended, and it is very dependent on the two parties, the right holder and the infringer and their relations, and of course the protection of consumers as that three-legged structure of trademark law. But the point is, right, that you have a property moment and it's validated, and of course all the validity requirements have the flavor of public law. Is the public going to be harmed by the grant of this right? Is this right worth granting to society, right? Those are all social welfare-based, society-oriented considerations. Once the right vests in a private set of hands, you pass more to a private law moment where we look at the interaction between the right holder and other private actors, mostly in two settings, right? Contracting, licensing, alienability, assignments, all kinds of private ordering, and then, of course, the infringement action, which is a classic private law interaction between an entitlement holder and a defendant who has at least allegedly violated the right. And so I kind of break the IP world into these two phases in order to better clarify, for purposes of fitting into this new private law literature, what is the private law nature of an IP right? And when does that nature sort of kick in and dominate? And how does it fit in the other set of entitlements we think about in private law interactions, given that there's this big statutory apparatus that's absent with classic private law interactions, a tortfeasor and a victim, two contracting parties, right? Strictly private actors. So the public qualification and then vesting of the IP right, to me, comes first. And that means the enforcement stage is inflected and maybe influenced by some of that property thinking and property grant moment in a way that makes it a distinctive private law entitlement, and yet still subject, I think, to the overall, private law structure or private law analysis. And the quintessential private law interaction is a tort, a harm, and we don't really think of the victim as having an entitlement violated. We often don't see it that way. But of course, there is this right inherent to bodily integrity. So when we're harmed, we have been affected in terms of a basic entitlement. We just don't usually focus on that. We focus on the act and the result and the cause and all that. But there is an entitlement to bodily integrity. My point is simply that that entitlement sort of speaks for itself. It arises in a kind of very natural way. We don't think much about that vesting because it vests just by virtue of us being people and of having a body to begin with. The difference between that entitlement, which is the right not to be hit or hurt or insulted or harmed, is very different from an IP entitlement, which requires all this statutory apparatus. But my point is, once the public phase of the IP process is finished, we arrive at a similar place because the IP right creates that top line in this side. That's a baseline entitlement that we can use to measure harm and to assess using the standard private law framework of corrective justice if an entitlement has been harmed and if a correction is necessary, right? So my point just started with sometimes in the literature on this new private law, we see IP just kind of absorbed into a private law structure. And I think there's something to it, but I wanted to clarify that there's much that goes on before we can draw that black line for an IP entitlement, before we can say this is a legitimate baseline against which to judge harm so we know where to correct back to, right? It's a contested baseline. Unlike bodily integrity, which is a natural right that we have, you have to work and go through a public law process in order to get an IP entitlement, which we consider solid enough to then be protected against harm, right? It's not as straightforward as simply saying, of course we have a right not to be hit. You don't naturally have a right, to an invention on a new microphone or a modified microbe or something. You have to establish its newness and its qualification by passing through these public law tests. Then you have a right that we can start to think about in the logic of private law, right? We can't just jump to it and say, well, the office granted this right, because post-grant review is crucial in IP law. So the public law phase is complex, right? It involves application, qualification, often interaction with a public official, certainly in patent examination. And even once the right is, quote, granted, it's very shallowly vested, right? About 60% of patent claims that are challenged in a post-grant review will be modified in part or completely invalidated. So the vesting of the initial grant is quite shallow. To get to that solid baseline, you need to have that thorough vesting that usually comes with a second or maybe even third defense of validity, right? So I just want to clarify that before we can talk about an IP right as a legitimate baseline for private law analysis, we've got to take into account the fact that there's a big statutory process to get you to that point, and that's different from other private IP interactions. In contract law, we have a right to contract with other parties voluntarily as long as it's not coerced, etc. Similarly, that baseline, right? You enter into a contract, both parties at that point we say have vested in a sense an expectation interest, right? And we protect that expectation interest by virtue of the fact of the natural fact that we can contract with each other as private agents, as private citizens. Again, it's not controversial. I have the right to contract. I own this piece of property. I contract to sell it to you. We now have a set of expectations which contract law will protect. That is a much simpler process to get to a baseline. The baseline is less controversial. It's not as contested, right? You may contest contract formation. You may contest the public policy defense to the subject of the contract. But mostly, the role of the state in the private law interactions is to enforce the rights of two private parties. And my point is, when you invoke the state to support an IP right, you are acting in that private law moment, but the right isn't created in the same simple way as contract and tort. It's a more complex process. Okay, so this is the backdrop that sort of explains what I'm trying to talk about in the paper. I only wish that I had put all this preface on to make it clear. When you look at the different IP rights and you sort of march down the list, you can think about the rights as qualifying or as the registration examination process. It differs in each case, but I just want to emphasize that that is really what establishes the legitimacy of the baseline entitlement. At the enforcement stage, I won't go through this in detail because I want to get to my main point. At the enforcement stage, though, you really do have more of a solid entitlement, and the analysis of infringement often has strong elements and strong affinity with tort law. Various principles of tort law are incorporated at the enforcement stage. And the interesting thing about IP rights, one of the million interesting things about IP rights, is that they have this dual nature, right? That they have these two sides, and that the public law moment is very different in some ways. It involves social welfare and overall, goodness for society versus the private entitlement side. And really what I'm trying to do this work is sort of figure out this dual nature, how to tease it apart, and how to talk about IP properly in the private law moment. Not simplistically, right? Not just, well, it's an entitlement, so, it's private law. No, because to earn corrective justice, to deserve the treatment of having an entitlement, you've got to earn it. And of course, in a lot of IP rights, you have to earn it every time you enforce it because the collateral estoppel rules are one-sided, right? The fact that I establish validity in case A in most IP regimes doesn't have much effect on the validity question in case B. I have to go through it all over again. The public law moment repeats itself every time you enforce. And again, that's very different from torts and contracts. Are you above 18 and it's a voluntary deal and there's nothing illegal? Okay, the contract expectation will be enforced. You were walking down the street, not hurting anybody, you didn't do anything, the truck ran over your foot, okay, bodily integrity will be enforced. An IP right, not so fast. Go back through the process again and reestablish that you have the right and the privilege, you've earned the privilege to call your IP baseline solid, legitimate, vested, and now we can apply corrective justice. We don't just assume and jump to it, because the grant by the state in many ways is just the opening act in the public law phase, and the enforcement phase comes later. Where do we see evidence of this kind of movement or interaction or interrelatedness of the property and the tort? Well, in Professor Bentley's own work in several places, but the one that jumped out at me in my reading was his discussion of the propertization of trademark law. It's a controversial topic in trademark. It's often improperly, he and I think agree, associated with a kind of overstrengthening of trademark, as if calling it property induces courts to overprotect. An absolutist view that property must be, extremely well protected and defended. He and I agree that's not true. In fact, trademarks are property and discussed as property, but in a different way and in a limited way. Propertization is not just sort of a momentary switch that's flipped and all of a sudden trademark gets treated like fee simple absolute in Blackacre. Not at all, right? But the point, I think, is that his work is understanding the relationship between the tort origins and the propertization moment, if you see what I mean. And to me, this is the right way to think about IP rights, which is they have common law origins. There is a property element, but the two phases or modes interact. They don't simply have discrete phases, right? There are elements of torts even in the property entitlement. There are limits, particularly on the property right. So if I was thinking about patents, just put aside trademark and copyright, and I want to think about the property aspect of patents, and then the more tort-like consideration of patent infringement. I kind of think about it in this way, that especially with claims, the claims can be thought of as a set of objects, described verbally, a set of objects, which, if you make, use, or sell them, will constitute an infringing act. So the infringement is measured by the list of things that are covered by the verbal formula of the claim, right? And we think of direct infringement as infringement that impinges directly on a protected thing. There are other aspects of patent enforcement, and this is what this paper is really about, that look more to the acts of various parties and how those acts affect the interest in things. But the acts themselves don't directly touch on. They don't touch and concern directly the list of things that are covered by the property right. The acts usually lead to or cause, in a kind of indirect or secondary way, harm to the list of things that are protected. But the acts don't directly implicate the things. And what I'm talking about here is what I talk about in the paper. The doctrine of equivalence also can maybe be thought of in that frame. But in the paper, I'm talking about the expansion of patent infringement liability beyond acts that directly touch and concern the things within the verbal set of patent claims. In other words, the shift to a concentration on, did this party act in a way that caused an actionable harm to the list of things protected by the property right, right? So we call this in patent law literal infringement, and we call it direct infringement. Why literal and why direct? Because those acts directly affect things within the patent claim. And there are other aspects of patent law that work this way too. You see in the doctrine of patent infringement vestiges of the property nature of patents. I'm going to talk about this in a minute. But the expansion of patent infringement liability expands the list of acts that people perform which are actionable harms related to the patented things, okay? And so the focus is on the acts which cause harm to the things instead of a direct impact on the thing itself. That may sound a little vague, but I'm going to try to explain it, okay? The propertization moment, I think, is an interesting moment to think about this, because when you take a set of duties, like to protect against deceit by a third party, right? Somebody starts using your brand and is tricking or fooling consumers. And originally, this is an action in misrepresentation, a deceit. It's an intentional tort to trick or fool somebody. When those duties are bound up into a property right, when a trademark goes from a cause of action to prevent harm and becomes embodied in a true property right, right? That moment is important. And that is another moment where we look at the interaction between tort duties and property nature in IP law, right? In this case, it's sort of the reverse of what I was talking about at first. In this case, we had a common law cause of action first. And then it becomes bundled together. All these duties not to trick consumers become bundled together, and you might say reified or concentrated in a true property right. And this moment of propertization, I think, is very interesting. The point is, and Henry Smith has talked about this, we want to relate the harms to the protected thing. We want to think about a direct harm to the property right as an actionable wrong. But when the right itself arises originally from common law interactions, it adds an interesting layer, I mean, I think, to the whole process. So if we think about the property aspects of IP and then the tort aspects, how would we sort of break it down? Well, the classic patent situation is you have to get it examined and granted, and then you can enforce it. In a standard common law cause of action, again, the entitlement is often not even mentioned. It's kind of implicit. What's the nature of the enforcement action? Because, especially in patent law, the right was closely associated with the property right. The initial early infringement analysis very much follows the law of trespass, right? And that confers various features on enforcement. But my point is, with the doctrine of equivalence and with some of these extensions of liability I want to talk about, that the trespass model is really superseded, or you might say added onto, by additional tort considerations. And so even though the origin of the analysis of harm to a patent starts with trespass, in many ways it expands to look more like an open-ended tort consideration, an open-ended tort analysis, misappropriation or restitution, right? And at this moment, you kind of move from a strict focus on was there harm within the bounded property right to a more open-ended consideration. Did the IP owner or creator confer some value on the defendant? Rooted into property, but in a way that goes beyond the property right, right? Simply a question of did they confer a benefit in the matter of restitution? You move from a narrow focus on the property boundary to a broader focus on what did the property owner do or create? What value did they add? And is it harmed in an actionable way by what the defendant did, right? And so patent law has this kind of schizophrenic or borderline personality feature where we're hyper-focused on the text of the claim during the literal infringement stage. And then all that goes out the window when we get to the doctrine of equivalence. And I know that after the Actavis case, you in Britain are struggling. How do we fit the doctrine of equivalence into the patent regime? And I'm saying the traditional way we do it in the U.S. is first highly under-theorized, second largely implicit, but third, I think, does follow this pattern of in literal infringement, we're very focused on a direct trespass type harm. Did this act directly affect a protected thing? And we shift to a broader concentration, a broader consideration. We think about the doctrine of equivalence. Did this inventor confer a benefit on this defendant in a way that we think should be actionable? Less rooted in the property and more focused on the harm, the conferral of a benefit and the harm caused by uncompensated use. In other words, restitution, right? So the doctrine of equivalence sounds more in a tort frame, even though the patent right begins life as a property right. And that's one of the points that I'm sort of trying to make. This question of whether calling something property leads to overprotection is a topic much discussed in IP. I think Professor Bentley and I agree. Calling something property does not automatically make it absolute or lead to or encourage overprotection, because property is complex, nuanced, multidimensional, and IP law shows that, right? We have in copyright a vast exception to infringement we call fair use. In trademark law, you register your mark, maybe even list a bunch of classes. But when you look at a trademark infringement case, the classes where your mark is registered have nothing to do with the common law flavor of the analysis called likelihood of confusion, right? So the registration moment is perfectly administrative, whereas the enforcement moment sounds more in tort. Did this defendant do something that reads on or makes an incursion into, right, the value of your brand in a way that the likelihood of confusion analysis should make actionable, okay? So calling IP property does not lead to substantive outcomes, in my view. And that's been a topic, that's been discussed in the field quite a bit. Anyway, I'm going to skip over this because I think I want to get to the sort of the main points before we run out of time. But I have seen this pattern in a couple of IP fields, and I mentioned them in these articles. Not only trademark, as Professor Bentley says, but I think the right of publicity in the United States now, commonly referred to these days as name, image, likeness rights, NIL rights. We're undergoing a propertization moment in the right of publicity that I find very interesting. And I root my discussion of it in this classic contribution by Professor Gordon, whose papers first stated that view of IP as the reverse of torts. She called it tort's mirror image. And she said, again, restitution is the conceptual foundation of IP protection. The moment when you have a set of duties that's transformed into a solid property right, a tradable asset, that propertization moment is what I'm talking about in this paper. So again, tort, property, interactions, overlaps, that's really kind of the flavor of what we're doing. Okay, so things versus acts. What are you talking about? What the hell is this? Right? Urges have come all this way to just blabber at us. Trespass, as you know, is a strict liability offense. And it just means you crossed the line, whether you wanted to or not, whether you meant to or not, even whether you really caused, monetary harm that's measurable. All irrelevant. It is a per se harm because it's an incursion into the property enclosure, right? Quaere clausum fregit and all that. Did you cross the line? Did you make an incursion into the protected zone? It is rooted in simplistic notions of liability because the liability follows from the nature of the right, the property right. A harm to property is a per se harm. Patent law direct infringement, literal infringement, has a strong flavor of this, right? It has a strong flavor of you crossed the line and that's all we need to know. Did you cross it or not? Not whether you intended, meant to, did it cause any harm, right? That is the property dimension of patents coming through at the enforcement stage. An indirect infringer is somebody who causes an infringing act but doesn't commit directly the infringing act. This is the canonical case I want to talk about of the contributory infringer, right? The contributory infringer is somebody who sets in motion a set of events which lead to a direct incursion. But that party is not themselves the perpetrator of the direct incursion. There's something missing in their actions, which means that their actions don't directly affect the protected property zone, right? The list of things covered in the patent claim, none of the things under that list are directly implicated by the action of this party over here. They set in motion events which cause a harm to the property. That's why we call them indirect infringers, right? And in this setup, we see, I think, some of the bones of the IP structure, which is, in the beginning, it was focused on a trespass kind of harm. But when we began to see parties earning money by causing third-party infringement, there was a tort-like sense that this kind of harm should be actionable, which required us to detach liability a little bit from a direct connection to the property interest. Do you see what I mean? The list of things covered by a patent claim are things that, when they occur, there's per se liability. But a contributory infringer does not directly cause or directly impact the list of protected things. They do something that encourages or causes or forces a third party to cross that line. But in so doing, under the law of contributory infringement, we say, you've committed now an actionable act. You've done something that impinges on the property interest, although you didn't directly harm the property interest yourself. You set in motion events that harm the property interest. That set in motion, that cause, you caused an infringing act. That's where you get the tort frame of patent infringement. That's what we can think of it conceptually as very similar. Now in torts, we say, did you start a series of events that caused harm? In IP, we say that you caused a series of events that caused infringement, right? Again, infringement we can call an actual harm because by this point, when we get to enforcement, we've established the validity of the patent limit. It's only legitimate to talk about this as causing an actionable harm if we rely on the entitlement as being solid and vested. But once you pass all that validity stuff and you say, yeah, this patent's good, this is a novel and non-obvious contribution to the state of the art, it's at least minimally valuable by the terms of the statute, we're going to enforce it. Then causing an impingement on it has become actionable as the law has expanded over time. Does that make any sense at all to everybody? You see where I'm saying and how I'm talking property tort, okay? It's basically the setup to this paper that I gave you. Now we get to the paper itself, and it'll probably make a little more sense. If you didn't read it, good for you, because you won't get confused. Now if you read it, you'll say, oh, now I know what Burgess was getting at. If you did read it, I hope this clarifies it a little bit. So the way I think about it is that the scope of a patent is the limit or the verbal contents of all the patent claim. The scope of a patent is all those things which, if they're created or caused by somebody, will be an infringement. Okay. The list of things that fall within the patent claim, those are the directly protected. That's the property zone, right? That's the zone where trespass applies. To trespass is to make you sell something that is claimed in a claim of a patent. It's to do something that directly impacts a claimed thing, right? When people began to observe a set of events where the direct infringer was not the focal point, where somebody who was not a direct infringer seemed to be causing harm, it required a shift in thinking away or beyond trespass thinking, because now we had to say maybe some harms to the patent are not direct harm to the protected thing, but instead are acts that cause a harm to the thing, right? So the list of protected rights in the direct infringement statute are those things which directly affect the existence, really, of infringing embodiments. Whereas Contributory infringement is an example of expanded liability because the party, the contributory infringer, doesn't do an act that directly affects the property interest. It indirectly affects the property interest. As we say, there must be a direct infringer in order for there to be an indirect infringer. There has to be a pushee and a pusher. The pusher is your contributory infringement. The pushee is your direct infringer, right? And the nature of contributory infringement is to say, oh, there are some acts that don't directly affect the protected property zone, but which should trigger liability. Once you get to that point, once you say there are some acts that cause harm which aren't directly and by that person's direct agency, immediate agency, affecting the property interest, then you're in the zone I'm talking about. I call that the enforcement zone or the zone of enforcement. I talk about the list of acts which, if performed, lead to direct infringement in a way that's actionable under the patent law, right? The list of acts that cause a direct infringement, but which are not themselves a direct infringement. Again, contributory infringement is the best example, but I'll try to explain how the U.S. statute has expanded over time. So this was the first foray into non-trespass thinking in patent law when the courts developed, again, in a very common law way, a very common law manner. If you read the early opinions where the courts are creating contributory infringement, it will be very familiar to those who've read cases on misappropriation, on the doctrine of equivalence, because we're talking in these cases about broad themes. Gee, they don't directly infringe, but they sure seem to be causing harm to a legally protected interest called patent. We can't get them for direct infringement. In this case, you're not selling something that's covered by one of the patent claims, right? The classic case of contributory infringement is maybe exemplified by a hypothetical patent on a four-legged chair, right? So our claim to the four-legged chair has a seat, four legs, and a back. Let's say you start selling a chair in the hardware store that has a seat, a back, and three legs. And you sell it right in the part of the hardware store where replacement chair legs are also sold, right? So you have a three-legged chair. As a seller, you're not an infringer. Why not? Literal infringement. What's it say? Seat, check. Back, check. Four legs, nope. Three legs is not four. Therefore, the seller of the three-legged chair does not directly affect, right, the list of things protected by the patent. All four-legged chairs are protected by the patent claim, but no three-legged chairs are protected. But what if you sell a three-legged chair in the section right next to the replacement legs, and it's screamingly obvious this unpatented three-legged chair is much cheaper than my patented four-legged chair, but you can do it yourself by buying the fourth leg, going home, and putting it on. When you go home and put it on, you are the direct infringer. You don't know it, but you've been pushed over that line. Oh, no, I infringed it. Why? Because I make, use, or sell the patented invention. I just made, by putting on the fourth leg, I am now using, by sitting on it, a four-legged chair. I'm an infringer. Now, the setup for contributory infringement was the obvious point that going after the consumers who put on the fourth leg won't do you any good because A, it requires too many lawsuits, and B, it's bad business to sue your customers. You know? We want you to buy a share, and by the way, there's a lawsuit that comes with it. That's not good marketing, no matter what. That happened in the file sharing wars, and we know what happened there. It didn't work out well in terms of PR. Point is, the buyer of the three-legged chair who puts on the fourth leg is the direct infringer, but the law developed to find liability and assign liability to this party. Why? They're the distributor of the three-legged chair. They're making money by pushing people over the line every chair they bought. Each sale of a three-legged chair, again, knowing that the fourth leg is likely to be put on or going to be put on, right? Knowing that, you have committed an act which directly leads another party to become a direct infringer, and we find liability. It's not a remarkable thing, right? It's an obvious filling of a loophole. It's the obvious process of common law expansion. But I just want to point out that when you make that little subtle move, you've moved a little bit outside property logic, and you've moved more inside tort logic, and you've exposed, again, the dual nature of IP rights. Literal infringement is still required. It's not that the patent claims aren't important. It's just that now a second-order harm a cause that leads to direct infringement becomes actionable. And in that little moment, you see an expansion of liability beyond a strict property definition. You've moved a little beyond trespass to shoving somebody into trespass. And when you do that, you're revealing more of a tort kind of analysis, in my view anyway. Okay? So that's the canonical case of contributory infringement. I'm not going to pound on the horse too much. I want to get to this is the acts and things distinction. Again, the thingness of property, as Smith says, the coverage of property right as a per se entitlement, which when incurred upon, if that's a word, when you make an incursion onto it, you've committed a harm. We've expanded that by saying there are some acts that cause that, which we're going to make actionable, right? So the expansion of liability takes on that sort of form. And that's what I mean by the enforcement, is to make the pusher liable and not just the pushee. If we had to follow a strict logic of property, if it had to be a classic common law trespass, breaking the clothes, then the pusher wouldn't be liable because they don't actually make that step, right? And I know that there are trespass cases where maybe we might extend liability, but just as a conceptual matter, you want to separate acts that cause infringement from direct infringement, right? Okay. What else do I want to say about this? That's probably going to make everybody confused. Basically the same point, except I just wanted to show that those common law forays resulted eventually in the U.S. Patent Act into a statutory embodiment or incorporation of the common law developed principle of indirect infringement or contributory infringement. You see this pattern in IP a lot, right? You see common law experimentation in the nature of private law case making. And then once a rule becomes established through the common law process, you often see a ratification, possibly a simple codification, but maybe a modification at the statutory stage. Again, we don't often think of IP rights as having a common law dimension, or we don't think about it often. But in a sense, it is more than a statutory field because of its relationship with common law lawmaking and private law thinking, right? And that's why it has this kind of dual nature, at least in my view. This is just an example of codifying an act that we would characterize as contributory infringement. And I'm just trying to recognize the simple fact that when you do that, when you expand the number of acts that are actionable, you expand what I call the enforcement zone, right? The property right defined by the claims is different, not coextensive, with the zone of enforcement. They're cousins, not twins, okay? And I realize that making a talk in Britain on the cousins is sort of twee, I guess, but we need cousins right now in our country. We need a lot more than that, but anyway, we're in trouble, folks. All right. So the direct infringement, make, use, sell in our statute in the U.S. Code is Section 271A, and the expansions all go and extend beyond 271A. And I'll give you some examples, and I'm going to stop because I just want to show contributory infringement is not the only example of this, okay? A contributory infringement I define here as selling an almost complete embodiment of the invention, and that's the simplest case. If you instruct an infringer, if you are a consultant and you say, hey, you can make a cool chair, make a back, make a seat, and put 4 legs on it. Again, you do not directly perform the act of making, using, selling. But if you guide, direct, instruct a third party to perform infringing acts, we will call you an inducer, right? We say that's inducement liability. Unlike contributory infringement, the inducer doesn't sell anything. He doesn't even sell a one-legged chair. He doesn't even sell a leg. He sells instructions on how to make a chair, and the recipient of those instructions becomes the direct infringer. Again, an expansion because the whisperer of the guide or the instructor is not performing the direct act that breaks the close of the property. A third party breaks the close, the client, the recipient of the guidance, right? But we make the guider liable as the most important proximate cause of the infringing event, which is actionable because the property right's been validated and established and all that, right? Okay. Other examples of this, this will really make you dizzy. I want to get to, I'll maybe just give you some examples. We have two versions of the expanded enforcement zone, and I'll just end with this. One involves exporting components of an assembly. So the patent claim covers an assembly. This would be a situation where you're exporting to Britain, let's say, a seat back, a chair, and 4 legs in separate boxes. So none of the boxes infringe the patent because none of them contain a fully infringing embodiment. But you send them overseas with instructions. Start with the bottom, put the legs on, and the back. When the user finishes the construction, they become actually not a direct infringer, curiously, because this act occurs in Britain. The assembly of the chair in my hypothetical happens in Britain, but it's still actionable under U.S. law. In this case, we've subtly expanded liability 2 ways. We've said that exporting all the components which can be assembled to an infringing device is an infringement. And even if the assembly happens overseas, we'll call that sort of a virtual or constructive infringement in the U.S. It's as if the assembly happened in the U.S., even though it doesn't. It's an expansion of liability. And again, when you read the cases that originated this thought, they're all about, this is a loophole. People are getting around the patent. They're harming the patent interest with this clever workaround. Oh, I won't export a full chair. That's actionable. I'll export the parts and instruct somebody to assemble, right? We have the same thing in reverse on importation, where if you have a process patent and it produces an output like a recipe that makes chocolate chip cookies, right? And you execute the process overseas, like Switzerland, and then you send the cookies to the US. Sending the cookies is not a direct infringement because the patent is on the process, the recipe. But we say, again, by expanding the notion of liability, by running the process and then taking the output and importing it, you're affecting the patent interest, even though you haven't directly infringed. When you sell cookies in the US, you don't infringe a patent on the process of making cookies. But under this expanded view of patent enforcement, we say, yes, you do. And that's part of the 1952 Act too. The point is, and I run through some other examples, the point is that expanding the zone of those acts which cause harm separates or distances the enforcement moment from the property right itself and makes patent law into more of a tort-like vehicle and less rooted strictly in the property right. It's not that it's not a property right. It's that the enforcement goes beyond direct harm. It expands the zone of liability. The closest analogy I can think of in the real property world might be the difference between trespass and nuisance, where we had to reconceptualize harm to the property interest because there was no physical breaking of the clothes unless you get into stuff about microscopic particles and stuff like that. But generally, we expanded the protected zone of a property interest under nuisance law in a way that separates the harm. There's no longer a direct physical incursion in a way that's noticeable and actionable, but we still think that a nuisance is harming the property interest. In the same general way, we expand the zone of infringing acts to separate or move 1 degree away from the property right itself, okay? So what am I trying to say? IP is both a property element and a tort element, and they interact in ways that I think are interesting. And if we're going to talk about IP as a private law issue, we have to frame it right. We have to understand that this is a different kind of entitlement than a lot of other private law entitlements. Okay, I said I could talk all night, and I darn near proved it. I'm sorry to go over. Always happens. I really am hoping this phase is the most interesting phase, which is your questions for me. Now,